Good evening, everyone. Welcome to this evening lecture at the Institute of Advanced Legal Studies. My name is Jules Winterton. I'm director here at the Institute, and it's my great pleasure to introduce Justice Azahar Mohamed. Justice Mohamed is at the Federal Court of Malaysia, the highest appellate court. He's no stranger to London either, having originally got his LLM at the LSE. He's held many judicial offices throughout his long career, but he's currently the Inns of Court Judicial Fellow here at the Institute. And I wanted to just mention this arrangement by which the four Inns of Court support a senior judge to spend some time here at the Institute doing research with us, and also participating in the intellectual life of the Inns. And I just want to publicly thank the Inns for that support for this annual arrangement. So I should say that Justice Mohamed is the first judicial fellow under this arrangement to come from Malaysia, and we're so glad to have him with us. His lunchtime seminar a few weeks ago on parallel legal systems and fundamental liberties was absolutely fascinating, and that's the subject of his research while he's with us. But this evening, his choice of topic is the reform of the Malaysian courts to achieve more speedy disposal of legal proceedings while preserving the quality of those legal proceedings, something that every jurisdiction struggles with. So I'd like to hand over to Justice Mohamed.
Thank you, Jules, for the introduction. Good evening, everybody, and thank you for coming. First of all, I wish to thank the Institute of Advanced Legal Studies for inviting me to deliver this lecture this evening, and I'm honored to be here. My subject today is the Malaysian experience of court reforms. In this lecture, I shall give a brief account of our experience of transforming our judicial landscape with the introduction of new measures to tackle massive backlog of cases and unacceptable delay in the litigation process. I will focus on the key initiatives aimed at strengthening our judicial systems and procedures, including efforts to address court management systems, procedural rules, and jurisdictional limit of courts, and the implementation of alternative dispute resolution. I will then highlight some of the accomplishments and the resulting outcomes of the reforms, and I will close by setting some directions which the court should take in the future. I became involved with the implementation of court reforms when I was appointed as the managing judge of the Civil Division of the Kuala Lumpur High Court in 2012. My administrative duty as a managing judge requires me, among others, to assist the Chief Justice to help set benchmarks and for efficient and equitable management of cases. In this regard, I am most thankful that during my time as an Inns of Court Fellow, quite apart from engaging in the intellectual life of the Institute, I have the distinct opportunity to establish networking with the judges here. It is through the fellowship I have had the privilege to discuss with some of the judges of at the Royal Court of Justice and the Rose Building about the way judges go about the principle of business business of judging in various divisions of the High Court in London. And over lunch and dinner at the various inns, I have had several conversations with the judges and the members of the bar on how cases are dealt with efficiently, speedily, and above all, justly, matters which are very close to my heart. I also visited the Judicial College to study the teaching programs, which proved to be very beneficial in respect of what to teach and how to teach judges. And for all that, I would like to record my deep appreciations to the Institute of Advanced Legal Studies and the 4 Inns of Court for offering me the fellowship. Now, more than ever, there are now few public institutions which are subject to more public scrutiny than the judiciary, as an institution established to resolve disputes on issues that embrace economic, social, political questions. A major challenge facing any judiciary is the ever-increasing public demand for judicial accountability. There is a continuous call for a more expeditious system of delivery of justice, effective and efficient resolution of increasingly complex disputes, transparency in the appointment of judges, as well as appropriate standards of competence and ethical conduct of judges. The year 2009 will feature as an important year for our judiciary, Malaysia, and the administration of justice as a whole. It was the year when, under the dynamic leadership of the then Chief Justice Zaki Tun Azmi, some of you may be familiar with his name, and his team embarked on multiple initiatives and reforms with the common goal of a higher standard of justice. Prior to the reforms introduced in 2009, measures and changes introduced were few and not sweeping in nature. The 2009 reforms were extensive and wide-ranging in nature and can be divided into 2 broad categories. First, a diverse range of measures that are intended to promote and facilitate a more transparent, efficient, and expeditious delivery system. Second, initiatives that are aimed at enhancing judicial skills in order to enhance judicial performance. Now, before turning to explain the nature of some of this reform, let me, by way of introduction, give you an overview of our judicial system, because some of you may not be familiar with our system. A significant event in our judicial history occurred in 1786, when Penang was ceded to the English East India Company. This was followed by what could be said to be the watershed of our judicial history, the granting of a royal charter to Penang in 1807. And upon the authority of the charter, a Supreme Court, presided over by a recorder, was established in 1808. And ever since, the British rule has had a most profound impact on the legal development of my country, with the introduction of common law and also the judicial system. Our present-day judicial setting, in terms of the structure, hierarchy, as well as procedures, is very much influenced by the British model. Now, our federal constitution, as the supreme law of the land, distinctly stipulates the separation of powers among the executive, legislative, and the judicial branches of the government. Though a federation, our judiciary is organized principally under a single unitary federal system, which I shall refer to as the civil courts. Our civil court structure is pyramid-shaped. The hierarchy of the courts begins from the Magistrates' Court, Sessions Court, High Court, Court of Appeal, and finally the Federal Court, which is the final appellate court. The High Court, the Court of Appeal, and the Federal Court are commonly known as the superior courts, while the Magistrates' Courts and the Sessions Court are commonly referred to as the subordinate courts. The bulk of cases are dealt with in the subordinate courts. Very few of these cases are ever reaching the upper levels of the superior courts. Now, let me at the outset clarify one point. In the context of this evening lecture, when I refer to courts, I'm referring to the civil court and not the Sharia court. And this is because presently a parallel Sharia court system exists alongside the civil courts. The Sharia court exercises jurisdiction over Islamic law and personal laws of persons professing the religion of Islam. And in my previous seminar and the roundtable conference, I had explained about how the two system works and how practical difficulties and jurisdictional conflict have arisen over the years regarding that dual system. But let me now turn to the subject this evening. A plethora of issues had dogged the civil courts prior to 2009. As in many jurisdictions, we were burdened with massive backlog of cases, unacceptable delay in the litigation process, and declining delivery of judicial works. The courts struggle with a mounting workload. Matters like efficiency, quality, transparency, accountability become major issues faced by us. There was long waiting time for trials, and often parties had to wait 4 to 5 years or even longer for a trial date. The time taken to dispose of cases were very long. Delays result in distress and anxiety for the litigants. In criminal cases, accused persons, even those on remand, had to wait for a long periods for their matters to be brought up to the courts. And all this led to delayed justice and frustrated litigants. Indeed, delay may defeat justice. In 2009, for example, we had 6,400 commercial cases pending in the Kuala Lumpur High Court, and most of these cases had been pending for more than 5 years. Some were as old as 10 to 12 years. And during that period, the Malaysian government had established a special task force to facilitate business, to address the urgent need for closer collaborations between the public and the private sector in order to enhance public service delivery with the hope of improving Malaysia's business environment. A representation was made by the task force to the judiciary of the need to clear the backlog of commercial cases. And during that period, the court processes were done to a very large extent manually. Cases were registered and processed at the counter, where physical case files were maintained and recorded into a register book. Courts stored information manually using paper and filing cabinets. This system served its purpose for many years, but over time, its limitation became apparent. There were improper organization of the court files, and the sheer volume of documents made retrieval of information difficult and time-consuming. And hard copies occupied a very large space, and because files moved from place to place, and unless they were properly recorded, we faced the problem of missing files. And during that time, our judges were writing notes of proceedings in longhand, which of course slowed down trial. Judges, I still remember when I became a judge in 2004, we spent laborious hours to take down notes. And later, the judge's secretary would spend many miserable hours to decipher the handwriting of judges. Somehow or other, the judge's handwriting is beyond, cannot be read. And we realized that there's no way in which this system can continue. This was the state of affairs before we introduced modern technology. And it was against this backdrop and set against this concern that I have narrated just now, that in 2009, the judiciary introduced a painful but a much needed framework program for transformation of our judicial landscape, which covers a wide range of structural changes and reforms at all levels of our courts. Let me now focus the method and approach undertaken at the beginning of the reform in 2009. For the first phase, we embarked on restructuring the court system at the main center at Kuala Lumpur. A decision was made that different nature of cases should be dealt with through different procedures. Key changes were then made to implement this. The focus was really to centralize the management of all these cases. Prior to 2009 reform, the High Court judges were in charge of their own registries and were thus responsible for the management of all cases registered in their respective courts until final disposal. There was no uniformity in the administration of cases between one court and another in the same division. The fundamental step we took was to rationalize the objective of case management. It had two prongs. First, it was used as a tool to eradicate the backlog of cases, that's number one. And the second, at the same time, ensuring speedy disposal of current cases. The key to the changes was the division of these cases into those that were filed before a certain date, which we refer to as the cutoff date. So we identify a cutoff date, and for commercial and civil cases, before 1st September 2009, they were dealt with by judges designated as judges in the old civil and commercial courts. And these judges were given the task to hear all those backlog cases until final disposal. And for the new cases, after the cutoff date, we created what is known as the new commercial court and the new civil court. Let me explain a bit more how the judges in the old commercial court and the old civil court dealt with this backlog of cases. Realizing that a judge has to deal with both interlocutory matters as well as conduct full trials, we isolated these two types of work. Each will be handled by a different set of judges. The objective was to allow hearing of full trial judges to focus on the disposal of cases fixed for trial before them. They are not to be burdened by interlocutory matters. So what essentially we did was, for interlocutory matters such as summary judgment, striking out application, injunction, amendment to the pleadings, it is to be handled by only a certain group of judges, which we call A track, referring to affidavit. While for the full trial cases, we assign it to judges who only do T track, who only do full trial cases. Now, I have mentioned a moment ago that cases filed after the cutoff date, we created new courts, right? So these are cases which were current at that time, cases that were filed after the cutoff date. We created the new commercial and the civil courts. And all cases filed after this cutoff date are handled by an entirely different set of judges than those filed prior to the old cutoff date, so that this set of judges can only focus on hearing of current cases. And for these new courts, the new commercial and civil court, we introduced a new regime of case management and much stricter timetabling of cases by which different stages of litigation should be completed. And the target for them to finish the new cases was 9 months from the date of filing. With two sets of court operating two different systems simultaneously, this has produced encouraging results in the disposal of cases. The introduction of these two different systems provided a more efficient and economical means to resolve the problem of backlog of cases. Now, to monitor the implementation of this scheme, of this of two systems which operate simultaneously at the same time, the Chief Justice appointed a number of managing judges. These managing judges are appointed among the judges of the Federal Court and the Court of Appeal. Their responsibilities are purely administrative in nature. They are assigned to look after a certain area and micromanage the courts throughout the country. They monitor the progress of the judges in that location by conducting periodical visits and continuous supervision to assess their performance. The managing judges monitor meticulously the time different type and categories of cases take, the time that passes from the date of filing to the date of hearing, the number of interlocutory hearings, the workload of individual judges, and the time taken to deliver decisions and written judgments. Now let me turn to say something about mindset and culture. We recognize that if reforms were to work, they would require a change not just in the structure of the court, but also in the culture and mindset of the lawyers as well as judges. There was, for example, a period of time where last-minute applications for adjournments of hearing were often readily entertained by the court on very flimsy ground. This contributed to the waste of judicial time and hence delay in the disposal of cases. Unless a judge is strict in refusing postponement and is committed to disposing the case or matter before him expeditiously, these new reforms aimed at eradicating the backlog of cases would fail. So it is necessary to convince the lawyers and judges to change their mindset. Under the new regime, courts are strict in the granting of adjournment, and cases are managed to proceed to its completion in a single sitting where possible. When this was strictly enforced, quick protests came from the members of the bar, and much was said about the injudicious exercise of discretion by the court on the one hand, and the flimsy application for adjournments by members of the bar. But in the end, both parties understood that a proper functioning of the system, adjournment of cases should only be granted very sparingly. Practice direction were then issued to regulate the handling of cases and fixing the time. This in turn has brought about in some changes of the mindset of both judges and counsel on the issue of adjournment. But still, even today, the never-ending adjournment of cases would not go away completely. And in fact, this is the difference. When I had occasions to speak with the judges here, I think the issue about adjournments never arise here, you know. Somehow or other, back in my jurisdiction, this issue is still a problem which we are facing, where cases are being adjourned on what we call flimsy ground. And we are now trying to change that mindset and that culture, but still, as I said, adjournment cases still have not go away completely. Now, meanwhile, it is also necessary to ascertain a reasonable number of cases of all matters for each judge to handle. And one of the most important features of our reform is that we set performance indicators and measurable benchmarks so as to meet the need for timely access to justice. Judicial accountability has been and continues to be addressed by the introduction of performance indicators. Time goals have been implemented to measure the time taken for the disposal of a matter from the date of filing to its completion. The introduction of a system of active case management by judges represents a very significant change in the litigation culture. Under the old regime, litigation process operated along traditional adversarial principle and left entirely the control of the litigations to the parties. The judges under the old regime took a passive role in the trial and pre-trial processes. Judges generally saw their job as that of a neutral umpire whose procedural role was largely restricted to resolving disputes between the parties. But under our reform, we encourage judges to be involved in the decision-making process from the moment the claim is filed. Judges are expected to spend a much greater of their time reading and preparing for cases. The aim is to encourage the parties to settle and also to use alternative dispute resolution and also to identify real issues for the trial. Now, once the structure of the court was reorganized, we then moved to another step of our reform. We upgraded the computer elements in the courts by installing and applying a comprehensive use of modern court information and communication technology to improve efficiency, access, and speed. It is inevitable that the judiciary must invest in modern technology in order to become more business-like approach. The initial priority was to strengthen the infrastructure so as to create a system that was fast, efficient, modern, and also secure. Presently, the technology which is utilized is what we call the e-court system. E-court system comprising 4 components. And let me say a word about each of these components. The first is what we call the case management system, CMS, which is the main component of the e-court system. This is a software program specifically designed for the Malaysian courts, which enable us to record and track the progress of cases. This system features a computer network which allows access to information on the network at a click of a mouse. CMS provides an integrated system for managing the cases that allows for computerizing file tracking, scheduling of trials, retrieving of statistics, managing report, and monitoring the cases. And this is previously, as I mentioned earlier, all cases were registered manually at the registration counter and were recorded in a course book. But under the CMS, which we have created, record of a case, all are computerized. And this information is retrievable at any time. The second component of our e-court system is what we call the court recording and transcription, in short, CRT. This system, installed in all courts, records the entire proceeding in court electronically in an audio-visual format. The court proceedings are recorded by 5 cameras installed at strategic locations in the courtroom. It automatically edits the visual to facilitate the person who subsequently transcribe it into print by identifying the speaker. And this is a drastic change in the sense that, as I've mentioned just now, previously the record of proceedings were done manually in the handwritten form. The third component we have is what we call the e-filing system. By this system, documents, writ, and all court documents are now filed electronically, thus taking up very little physical storage space. This system provides an avenue for lawyers to file their court documents through the internet via the e-filing portal. The greatest advantage of this system is the ability to recall any document filed in court without the need of a physical file. E-filing is designed to improve court efficiency and provide some of the following benefits: online registration of cases, online verification of documents. It allows search online, payment to the court can now be made online via internet banking, and also interactive alerts and online notification of filing status. And the last e-court component is what we call the queue management system, which is designed to manage the scheduling and waiting time for cases which are fixed for case management before the court. Previously, lawyers and members of the public had to wait for their cases to be called out by staff members of the court. With the implementation of this system, lawyers are able to record their attendance using the kiosk provided in the court premises. The kiosk then will provide confirmation of whether the case is listed and provides information in relation to the venue of the hearing. Lawyers have the option to also register for a short messaging system SMS alert, which means that they will be informed via SMS when their cases is ready to be called. The success of the reform strategy and program initiated in 2009 can be attributed in large part to the introduction of the cohesive modern technology, which was closely matched to the judiciary core objective. Our e-court system has, in my view, made the biggest impact in enhancing the judicial system and in dealing with our backlog of cases. In fact, there is a steady increase in the number of requests from foreign jurisdictions to study our e-court system. We are mindful that technology alone does not improve the entire system. At the same time, in tandem with the application and extensive use of modern technology, the changes and reforms also span across other dimensions. And let me touch some of these other reforms. First, on the redeployment of cases away from the High Court. One of the most notable general trends in the civil justice system of most common law jurisdictions, including in UK, has been to redeploy cases away from the Superior Court, from the High Court. Cases which previously would have been heard by a High Court are now routinely tried by a judge of the court subordinate to the High Court. We followed similar trends by way of amendments to our Subordinate Court Act, and which came into force on 1st of March 2013. For example, the jurisdiction of the Session Court is now increased to 1 million ringgit from 250,000 ringgit. 1 million ringgit is roughly about 200,000 pounds, which is now within the jurisdiction of the Subordinate Court. It now also has jurisdiction, Subordinate Court has now jurisdiction to grant injunction, declaration, specific performance, and which were previously under the exclusive jurisdiction of the High Court. With the amendment, there was a reduction of more than 50% in the number of writ action filed in the High Courts. Let me now talk about court annex mediation, which I think is not something not commonly followed in UK. The court annex mediation is a reform that we were very much influenced by the American system. Although dispensing justice in civil and criminal litigation remain our core judicial function, we introduced what we call the court annex mediation as an alternative to litigation in 2011. This alternative mode has since then been integrated into the court process. Mediation processes are now widely practiced in our courts and exist alongside the traditional dispute resolution of having a dispute adjudicated in the courts. The court annex mediation program is a free mediation program using judges as mediators to help disputing parties in a litigation to find solution and to encourage settlement of dispute without trial. Every judge now plays an active role in facilitating and promoting mediations. Judges may suggest a mediation to the parties and encourage them to settle their disputes at the pre-trial case management stage or at any stage in the proceedings, even after a trial has commenced. Through mediation, the court attempts to help the parties to reach a settlement by acting as a go-between, articulating and explaining the views of each of the parties. The court fulfills an intermediary role rather than being an active participant in that resolution process. Next, I deal with specialized courts. Specialization of court is another important step which has been initiated by the judiciary to tackle backlog and to expedite the disposal of cases. Specializations promotes speed, expertise, and efficiencies. Certain type of cases are now heard and decided in dedicated courts, such as in the Intellectual Property Court, the Islamic Banking Court, the Admiralty Court, the Construction Court, the Environment Court, the Coroner's Court, and the latest court that was established sometime this year was the Anti-Profiteering Court. With specialist court, cases are resolved faster than they were before. Now, we are conscious that in our quest for greater efficiency and speed in the disposal of cases, justice cannot be compromised. This is addressed by emphasizing the importance of the quality of judgment handed down at all levels of the judiciary. It is therefore vital that a judge should accept that continuing legal education is part of the job. We observe that most countries with well-developed legal system and judiciary have judicial training institutes or colleges. We realize that a continuing judicial training is important to enhance the skill and compatibilities of our judges to meet new challenges. And to this end, the Judicial Academy was set up as a training institute in 2012 with the objective to ensure that judges acquire and develop the skill and knowledge necessary to perform their role to the highest professional standards. The teaching programs include the teaching of substantive and procedural law, the teaching of judgment writing, the teaching of judgecraft, the teaching of legal ethics, and the teaching of management and internet interaction skills. The training programs presently run by the Judicial Academy fall into the following two categories. First, we have what we call an in-house training sessions conducted by senior appellate judges, and in their capacity as facilitators, these appellate judges conduct face-to-face training on substantive and procedural law that is regularly or might be raised in the court. The in-house courses are meant to be interactive, which requires active participation by judges. Second is a program run by the Judicial Academy in collaboration with such bodies as the Securities Commission, Central Bank of Malaysia, and Kuala Lumpur Regional Centre for Arbitration. Under this category, the Judicial Academy invite eminent local and foreign speakers who are expert in their respective field to conduct workshops and to give talk to judges in specialized areas of laws. Judicial training and learning is an ongoing exercise for every judge throughout his judicial career in our country. Judicial training has now come to be an integral part of judges back home. Now, to improve our service to the public and stakeholders, we also introduced a unified and simplified procedural rules for the High Court, Sessions Court, and the Magistrates Court. The rules of Court 2012, which came into effect on 1st August 2012, standardized the rules of procedure relating to civil cases where only one set of rules apply both to the High Courts and subordinate courts. Previously, before the introduction of these new rules, each of the subordinate court and the High Court have their own set of rules. This rule has paved the way for a more judicial intervention in the court process. We have since moved from the system where the litigation process was controlled by lawyers. The litigation process is no longer controlled by lawyers, but instead the judge has a lot of say in the progress of the case. Previously, there was very little judicial management, and because of that, the process often degenerated into an excessively adversarial content. With more judicial intervention at pre-trial stage, we reduce adversarial techniques by encouraging more full disclosure of evidence by both sides. The new rules provide the extensive powers given to the court in case management and the willingness of our justice system to involve mediation as part of a dispute resolution mechanism. Let me talk now a little bit about judicial appointments. In 2009, the government enacted the Judicial Appointment Commission Act, which established the Judicial Appointment Commission, JAC, to address the issues relating to appointment and promoting of superior court judges. It has been debated that the previous system of judicial appointment did not satisfy the element of transparency in the selection process. A great deal now has changed in the selection of judges since the JAC was established. In fact, the JAC was the structure of the JAC also followed closely the UK JAC. The JAC was intended to provide greater transparency in the appointment of the judges. Among the functions of the JAC are to select and to identify and to select suitably qualified persons who merit appointment as judges, and also to formulate and implement mechanism for the selection and appointment of judges. In performing its function in selecting candidates, the 2009 Act expressly requires the JAC to take into account, among others, the following criteria: integrity, competency and experience, objectivity, impartiality, fairness and good moral character, decisiveness, and the ability to make timely judgments and good legal writing skills. The Judges Code of Ethics 2009, which was introduced in that year, renews our statement of values that the judiciary should always maintain the highest standard of probity in keeping with the principle set in the Banglaw Principles. The code is instrumental in the maintenance and enhancement of judicial independence, competence, and integrity. This code requires a judge to uphold the integrity and independence of the judiciary, avoid impropriety, perform judicial duties fairly and efficiently, and minimize the risk of conflict with the judge's judicial obligations while conducting extrajudicial activities. The court also requires a judge to declare his assets on his appointment. So I have given you a very general overview of our courts, of our court reform programs. What then are the results? In the initial stage of the 2009 reform, there was the inevitable confusion and teething problem as well as IT glitches. Many were concerned that the cases seemed to be rushed through. At the beginning, because the reforms were judge-led, one of the biggest challenges was to change the mindset of the lawyers and their instinctive resistance to change. The stricter timetabling of cases by which cases should be conclusively concluded, and the setting up of performance indicators and benchmark were at first greeted with much skepticism. But there is no turning back. Litigants and the lawyers have to keep pace with the changes that are taking place. We have set the timeline cases to be disposed of, be it at the High Court, the Court of Appeal, or the Federal Court. Judges too, in the beginning, had some reservation to embrace modern technology. It is a distressing experience for some judges to move away from familiar paper-based case file. Most judges are very used to handling physical papers and to see the words on paper rather than on the computer screen. But as the Bob in the Star Trek would say, resistance is futile. Technology has no respect for legal traditions. Judges progressively adapted to handling e-documents. After some initial hesitancy, judges agreed that the use of this system enabled them to conduct hearing and trial more rapidly and efficiently. They have changed their mindset. the use of modern technology has now become entrenched in the judicial culture, and this process is marching on with an ever-increasing momentum. After a period lasting less than 3 years, the broad range of reform that I have summarized just now showed a very promising and positive result in our judicial work. We have managed to finally eliminate our age-old affliction, that is to say, the backlog of cases that beset the judiciary and the administration of justice. As a result of all this, we now have a benchmark or yardstick by which cases can be resolved. Generally, for all cases filed in our subordinate court today, they will be dealt with, resolved, and disposed of within 6 months. And for the filing, from the date of filing, and 12 months for criminal cases. For the High Court, all new cases will be disposed of as a matter of rule of thumb within 9 months from the date of filing, and for criminal cases within 12 months. The World Bank, in its August 2011 progress report entitled Malaysia Court Backlog and Delay Reduction Program, stated that although conducted over a very short period, this reform has been able to produce results rarely reached even in programs lasting 2 or 3 times as long. The progress report further stated that the reform provided a counter-example to contemporary pessimism about the possibility of the judiciary improving its own performance. The World Bank noted that our reform, which is not radical in its content, offer a model for other countries dealing with similar problems. And in the course of writing this paper, I came across a book in the library, a new book entitled Asian Court in Context. It's a Cambridge University Press. It is a book which studies various reforms conducted by Asian courts. And the writer in that book, Asian Court in Context, has analyzed, in fact, the reforms introduced in 2009 and the resulting outcome. At page 403, the writer observed, and I quote, "With a relatively short period of 3 years, Chief Justice Zaki Azmi, the former Chief Justice, overcame the problem of backlog of cases and has put in place a system where all new commercial and civil cases are now disposed of within 9 months. The strategies adopted by the Chief Justice were not by any definition radical. They were, in fact, very simplistic and straightforward. However, these strategies were highly effective. Chief Justice Azmi did not merely address the problems that had beset the administration of justice in the country, but went beyond that. He laid the groundwork to ensure that the judicial systems and procedures were up to date and on par with those in other developed countries. In the words of one commentator, he restored faith in the judicial system." Unquote. We have come a long way since the start of our reform in 2009 in bringing the judiciary to the level as it is today. Although this judiciary-led initiative was introduced primarily to address the problem of backlog of cases and delay in the civil litigation process, what may not be apparent is that this reform also have an impact on matters such as culture and mindset, efficiency, competency, transparency, and technology. Modern technology promotes and facilitates accessibility to justice, ensures the expeditious and timely process, which in turn contribute to public trust and confidence, as well as judicial independence and accountability. In short, the optimum utilization of information technology in the administration of justice contributes to the integrity of the judiciary. However, we are mindful that litigants come to court not only to have their cases disposed of fast, but more importantly, to be disposed of justly. Expeditious disposal of cases should never be at the expense of justice. It is all a question of balancing the need to dispose of cases expeditiously with that of fairness to prevent miscarriage of justice. And in closing, let me say this. Today, more than ever, we are facing a more challenging legal landscape. The judiciary is faced with an ever-growing complexity in the way we carry on our core business of judging. We live in time of change. The justice system is changing with public demand and technology fundamentally changing the way justice is delivered and the way we work. The administration of justice is a dynamic and constantly evolving process. The demand on the justice system is increasingly greater as our nation progresses economically. And in a period of deep-rooted changes, reform is inevitable and significant changes must continue to improve access to justice for all levels of society that will have the effect of improving public trust and confidence in the judiciary, while having as its primary objective the goal of continued adherence to the rule of law. We must do our best to cope with and anticipate changes. In the future, we recognize where information technology is spread through the entire realm of human activity, there are greater expectations that justice is delivered efficiently, transparently, and promptly. If courts do not respond to the need to adapt changes, public confidence in the judiciary will be eroded. The judiciary must play its leading role and intensify efforts in ensuring that justice is efficiently, speedily, and above all, justly. That task cannot be left to others. I hope that this brief account of our experience of court reforms will be of some interest to you. Thank you so much for listening.